Thank you very much, and thanks for the invitation to speak here today. I'm going to try to avoid overlap with previous speakers, which is always difficult when you come close to the end slot, I suppose. But so I'm going to be taking sort of a high-level view of the issues involved in surrogacy tourism, or international surrogacy arrangements, as I suppose they're also known, best interests and human rights. So I suppose to start with, the reality is that we're living in what might be called a cyber procreation era. And the Wall Street Journal recently did a piece on surrogacy which they entitled "Assembling the Global Baby." And I suppose, as some people have mentioned already, that really with a few clicks of a mouse on a credit card, you can assemble a global baby using Google, Facebook, Twitter to buy sperm from an anonymous Danish man, eggs from an anonymous Spanish woman, and the services of an Indian surrogate mother, all from the comfort of your own home. So the price that one pays for this depends on the socioeconomic situation of the destination country and consumer preferences about where they want to go, and language difficulties and so on. And there are many reported concerns and in the literature around the quality of the information that the intended parents can access on the internet, difficult conflict of laws and immigration problems, potential for exploitation of women. So I suppose what I want to look at more particularly is how should we best protect the safety, security and well-being of surrogate mothers, children and intended parents. My view is that we need a reality check in terms of, I suppose, the limitations of national law in this area, or the circumvention of national law perhaps would be a better way of describing it. My own view is that prohibitive national laws are powerless, or at best symbolic, in this area, given the ease of access to foreign reproductive services as I've just described. And I think these prohibitive laws lead to the expansion of international markets and open up the potential for exploitation elsewhere. And I wonder, are we really serious when we talk about exploitation and prohibiting exploitation? Do we check to see if Indian or Mexican women were supported or exploited? Do we check how much they were paid? Did they receive adequate care? Were they coerced? I don't think any real scrutiny takes place, and in reality, despite prohibitive laws, intending parents usually end up with legal recognition of their parenthood anyway. So I think the baby Gammy case probably illustrates some of the difficulties here, and many of you will be familiar with that from the end of 2013. So what happened in this case was, despite the fact that commercial surrogacy is illegal in all Australian states, only 3 have legislated against international surrogacy, and this doesn't appear to work as a deterrent. 25% of all international surrogacy arrangements are undertaken by Australians, so the prohibition doesn't appear to work very well. So in the baby Gammy case, a 21-year-old Thai married mother of 2 agreed to act as a surrogate for an Australian couple for a fee of the equivalent of €11,000, and this resulted in a twin pregnancy, a boy, Gammy, and a girl, Pippa. So Gammy was diagnosed with Down syndrome, and the finals, the Australian couple decided to return to Australia with Pippa only. And this led to a huge sort of international media outcry. The media then subsequently reported that Mr. Farnell had 22 previous convictions for sex offences. There were conflicting stories in the media about egg donation, about whether the Farnells had requested the surrogate mother to have an abortion when the Down syndrome was diagnosed. They said that they had always intended to return to Thailand for Gammy, and that was disputed. There was a question about whether they had sought a price refund because they didn't get what they had bargained for. But ultimately, there was no criminal offence involved. Subsequently, a lot of money was raised internationally, I suppose, through charitable efforts to support Gammy and the surrogate mother in Thailand for any medical expenses that were required. And in January of last year, Gammy and the surrogate mother were granted Australian citizenship through Mr. Farnell's paternity. And Thailand recently restricted surrogacy to heterosexual couples married for more than 3 years. One of them must have Thai nationality, and only payment of reasonable expenses allowed. So I suppose in reaction to that international controversy, they have sought to cut back on the possibility of tourism into the country for surrogacy. The reality is, and we've heard this already today, I think, that surrogacy tourism is on the rise. The Hague Conference report says it's been rising to 1,162% over the last 5 years. There's over 1,000 babies, much more probably than 1,000 babies brought into the UK and Australia alone each year. and we've seen from previous papers that it's increased in the UK from 2% of parental orders in 2008 to 44% in 2014. And that's been accompanied by a growth in demand worldwide for surrogacy in countries, particularly where the intended parents legislatively can acquire custody relatively easily, such as the ones that I've mentioned here. National reports show that couples and individuals indeed are willing to go to great lengths to circumvent the law and find alternative ways to bring about their intended parenthood. So, for example, a report on Guatemala describes a new practice, and maybe I'm not so sure if it's new, of married men having an affair and impregnating a woman of lower socioeconomic status who is in fact intended and paid to be a surrogate and will hand over the child to the couple once it's born. And that's because in Guatemala surrogacy is not permitted. So they get around that, circumvent that by this practice. And it also highlights, I think, the ability of individuals to arrange surrogacy without the involvement of medical practitioners, which makes it, of course, difficult to regulate, because if it can be done outside of a clinic environment, then it becomes much more difficult. And thus for surrogacy to operate even in countries where assisted reproductive techniques are not readily available. So I want to look very briefly at two countries in particular. The first is India. So surrogacy has been legal in India since 2002. It's the largest provider of commercial surrogacy in the world, about 25,000 births per year. Surrogacy treatments cost about 30,000, and that excludes all the extra expenses of travel, accommodation, genetic testing, and so on. The surrogates themselves are usually paid less than 30% of the fee paid by the intended parents. And there's been lots of documentation around Indian women allegedly being recruited from very poor, uneducated classes, sometimes the surrogacy being arranged by their husbands rather than by the women themselves. There's concern about the women being uninformed about the risks that they're undertaking. They're housed in hostels, mattresses on the ground. There are multi-embryo transfers, and then if there's a multi-fetal pregnancy, then there's a request for a reduction of the pregnancy by the intended parents. There's certainly a lot of questions about aftercare. As soon as the baby is born, the women are sometimes just discharged, I suppose you'd say, from the care of the clinic. And there's also stigmatization risks for these women when they go back to their local communities because they've been pregnant with another man's child, and sometimes they are ostracized from their own communities. So in saying all that, I suppose, and I don't want to step on the toes of the next speaker who's going to talk about exploitation, women in India reportedly do not always see their role as being exploited. Surrogacy is described by some of them as a selfless act of Buddhist merit. Many of them reportedly feel that surrogacy is better than the alternative, which might be other immoral things such as prostitution. And they use the money to build better futures for themselves and for their families. I suppose when we talk about exploitation, we have to think, is it the fact that money is paid? Is it the amount of the money that's paid? Or is it the fact of these other issues about care and support and counselling and the physical risks that they undertake for what we might consider to be a very low amount of money, but for them it enables them to lift themselves out of poverty, perhaps to an extent at least where they can buy a house for themselves and their families. And if we prohibit that, what are we doing for these women actually? Are we offering them any other safer, better alternative to lift themselves out of poverty? Or are we just saying, well, you can't have that option because we think it's unethical, and therefore you can stay in your poverty because we don't think that it's right? Recent developments in India, there's a draft assisted reproductive technology bill which is trying, like Thailand, to restrict the surrogacy tourism. So again, it will be restricted to people who have a link to India, and prohibition on commercial surrogacy. At the end of October, even though the bill isn't yet passed, the government sent a notice to fertility clinics ordering them to stop all surrogate embryo transfers for non-Indian passport holders. So the reality is that as Thailand and India close up the possibility of surrogacy tourism, other states will open up, such as Mexico. So we're not going to, I suppose, easily prevent that. Different situation in the United States. It's very overtly commercial, I suppose, and you have the celebrities, some of them are depicted here, the celebrity endorsement of surrogacy and the happy ever after story. So it's quite a different scenario there. Each state creates its own family law regime, resulting in lots of different definitions about parenthood and what rules there are about whether surrogacy is legal or illegal. I'm not going to go through all of these, but some states obviously ban all types of surrogacy. Other states allow for enforcement of gestational surrogacy only if certain conditions are met. And California then is regarded really as, I suppose, the surrogacy capital of the United States. Some agencies there estimating 50% of the births are for international parents. And you can see that the arrangement typically costs on the much higher end of the spectrum, from 75,000 to perhaps 120,000. And certainly there are couples from Ireland who have been to California and will probably continue to go to California for the ease and the security that it offers in terms of recognition of their parenthood. So I want to talk briefly about the human rights issues, I suppose. So as we know, there are obviously a wide diversity of attitudes and legal approaches worldwide to the issue of surrogacy. And the challenge really, I think, is to try to reconcile substantive differences in a way that surrogacy is viewed through a rights-based perspective, because this isn't just an issue of private international law or jurisdictional disputes. It's really more questions that go to the core of the concept of parenthood and certainly raise serious concerns about potential abuse and exploitation. So firstly, to mention children's rights issues, and I'm going to stay away from the European Convention on Human Rights because Andrea has already spoken brilliantly about that. So just want to mention the UN Convention on the Rights of the Child, which has obviously huge implications in relation to the rights of children across all aspects of their lives. But the implications for children who are born through assisted reproduction or surrogacy are not expressly mentioned, unsurprisingly, given the time at which it was drafted. So I suppose Articles 3 and 7 probably are the most relevant perhaps to this area. Article 3 talks about the child's best interest being a primary consideration. I'm becoming more and more ambivalent, I suppose, about the best interest test. I think it's certainly important in directing states as to how decisions should be made, but I think it's also very vague. And it's also perhaps subjective and overly broad because it allows scope for widely differing interpretations, and it has the potential to mean all things to all people. And Article 7 then talks about the child having the right to know and be cared for by his or her parents. So how do these principles, broadly stated principles, apply in complex international surrogacy arrangements? Firstly, in relation to the recognition of parenthood, and that's in keeping with Article 7 and the child's right to know its parents, I suppose, there's a multitude of ways in which commissioning parents avoid the restrictions or lack of regulation on surrogacy and use alternative legal mechanisms to ensure that their intended parenthood is recognised. Most commonly they use adoption, sometimes they use guardianship, and sometimes parental orders, as in the UK and elsewhere. In some cases, the child is fraudulently registered as the natural child of the intended parents. The effect on children, of course, we know that parents don't always apply for parental responsibility orders in their home states, and this can lead to very insecure status for children. There's also concerns where this arises, I suppose, for medical interests of children. So there was a recent Canadian case where a couple signed a contract with a Mexican clinic. Premature twins needed medical care after birth. The bills were not covered by the small print in the contract with the clinic. The parents couldn't afford to pay these medical bills. There was a very complicated legal parentage issue, and so on. And to date, as was mentioned earlier, the studies of the well-being of children don't focus specifically on children born after cross-border surrogacy. When it comes to the best interest test, there are diverging views in some countries, such as Ireland, as we saw in the MR case. I suppose the decision is made according to the welfare of the child, but the normative values that go into making such a determination can vary dramatically. There's a clash of ethical positions between countries who favour the maintenance of maternal bonds because they think that's in the best interests of the child, and those who prefer contractual certainty. So in Argentina and Belgium, for example, there's no recourse for the intended parents. The surrogate will remain the legal mother, whereas in Greece, as already been mentioned, the intended parents gain custody and the surrogate mother has no rights. So this can arise obviously in the rare situations where there's a custody dispute between the surrogate mother and the intended parents. It can also, the question of best interest can also arise where there's, I suppose, a clash between the welfare of the child and the issue of public policy. So I'm not going to go through these examples because of time, but so we have examples from Australia, Brazil and Canada, and indeed the ECHR cases, I suppose, where the best interests of the child, the welfare of the child, will always trump public policy considerations, really, and I think that that's inevitable. And we also have examples from England, from the X and Y case and the L case, which have already been discussed, of a very pragmatic approach, really, that there's a fait accompli. You have a child who has been conceived by a surrogacy arrangement abroad, even if the provisions of the legislation have been breached. You still have this fait accompli of the child, and its welfare has to be prioritised. I suppose my main point in this area is that there's a need for an international approach, I think. And there's a couple of examples here from English case law where Judge Moylan says there is a compelling need for a uniform system of regulation to be created by an international instrument in order to make available an appropriate structure in respect of what can only be described as the surrogacy market. Similarly, in Australia, Judge Bryant recently called for an urgent federal inquiry into international surrogacy and said Australia was being extremely irresponsible in not dealing with the problem of surrogacy tourism. And she said that we're allowing the birth of children overseas who will never know their biological mother and have no means of finding out who that might be. So the way forward at domestic level, I think, my own view is that we should recognise and regulate domestic commercial surrogacy. I think we should have adequate supervision and control of quality and safety issues to make sure that the well-being of the surrogate mother is at the centre. She should have counselling and independent legal advice. She obviously should be in a position of being able to give from a capacity point of view and also from a counselling and legal advice point of view, being in a position to give informed consent. We should be able to ensure that best clinical practices are observed at all times. I think there should be approval of arrangements by courts or specialist bodies such as the Adoption Authority prior to embryo transfer, rather than an ex post facto exercise in futility, as I've already mentioned. Once the child has already been born, it's really an exercise in futility to try to explore the issues of consent and payment at that point. Ultimately, the child is probably going to end up in the hands of the intended parents anyway. Concerns about the commodification of children, I know John's going to speak about this as well. So I think the legislation should recognise that the intending, who's usually the genetic mother, should be the legal mother. And even if she's not the genetic mother, my own view is that the intending parents should be regarded as the legal parents. There will be challenging issues, obviously, when the law is flouted, and they will be ultimately decided, I suppose, on a case-by-case basis. The way forward at international level, the Hague Conference on Private International Law demonstrates huge diversity of regulatory approaches. It's interesting to see that issues relating to this situation have been discussed at the UN Committee on the Rights of the Child in 2 different state reporting procedures in 2014, so it's becoming much more of a concern, not only in relation to human rights, but also in relation to children's rights in particular. So there is a growing need for international work in this area, and the Hague Conference says that work should continue to explore further the feasibility of drawing up a multilateral instrument. I think that any attempt to impose a complete prohibition on cross-border surrogacy arrangements will not succeed. Experience of other countries shows us that. You could have, I suppose, conceivably bilateral agreements between individual countries that are willing to address the issue, but I think it's much broader than that, and the need is much broader than that. You need a multilateral approach because there have been a number of cases, obviously, which involve more than 2 states. So you could have the intended parents residing in one state, maybe not the state of their nationality, maybe not the state that they intend to raise the child in. The Gammy providers and the surrogate mother could also reside in different states. So you've immediately got potential for a big conflict of laws and jurisdictional problem. I think the international convention, were it to be agreed at a very basic level, should agree codes of practice and minimum standards for those providing services. They should enhance staffing and training in embassies and consulates in specific countries to make sure that accurate information is being given to those who require it. I think you need to incentivize parents to seek a parental order to make sure that the security of the status of the child is prioritised. So they should require a parental order before a passport is issued. And obviously the safety and security of children. I think the best interest test is a little bit ambiguous, but I think we're probably stuck with it. It's been around for so long, whatever it may mean. And just finally, I suppose, in relation to the payment of surrogate mothers, because that's going to be a big issue of controversy if you do try to agree a consensus in relation to an international convention. I think we need to strike a balance between an altruistic model where only legitimate expenses can be reimbursed and a commercial service where surrogate parents can set their own price. And there's been a suggestion from Trimmings and Beaumont that surrogate mothers should be provided with income for a year. So during the 9 months of pregnancy and the 3 months after birth. And they're suggesting that it should be set at the wages lost if the mother was employed, or if she's unemployed, at a fixed sum, perhaps 3 times the minimum wage in that country. And I think obviously there are risks with payment because it could act as an instrumental sort of incentive for the surrogate to agree to surrogacy for purely economic reasons, particularly where there's a large divide in a country between the very rich and the very poor. 3 times the minimum wage may represent a sum that would never otherwise be hoped for in the normal course of one's life. But I think we need to have a discussion about whether, on the one hand, it is more exploitative or devaluing for the woman to reduce her reproductive ability to a mere economic resource, or on the other hand, if a lack of payment actually makes surrogacy more oppressive and adds to women's exploitation. And I think if we in Ireland just allow for expenses-related surrogacy, the reality is that international surrogacy will continue. We won't prevent that because most people in Ireland will not have the ability, I suppose, to engage the services of a woman who will act altruistically for them. They may not want to ask a friend or a family member to do it for them because there are difficult dynamics in that relationship as well. And so international surrogacy will continue. We either need to deal with it full on in the domestic legislation when it arrives, or we need to push, I suppose, for an international convention and try to get some consensus at that level. Thank you very much.